hemos conseguido a lo largo de estos años tener una magnífica selección de árbitros internacionales que han podido dictar estas conferencias. Fruto de las conferencias Hugo Grocio es este libro que editamos justo antes de la pandemia, donde hemos recogido todas las conferencias, y es una de las actividades principales del CIAMEN. Lo solíamos hacer en la Academia de Jurisprudencia y Legislación, pero como sabréis muy posiblemente se encuentra en plena renovación y era imposible hacerlo en esa maravillosa sala tan tradicional y tan clásica que nos acogía todos los años y nos acogía la academia, y era una magnífica oportunidad de poder estar allí. Bueno, hoy lo hacemos aquí en el aula magna de la Universidad de San Pablo CEU, que como sabéis es el marco del CIAMEN más moderno, pero tan, espero, agradable la sesión como las que hemos tenido a lo largo de los últimos años. Bien, hoy tenemos al juez Bruno Simma como invitado. Va a hacer Juan Fernández-Armesto inmediatamente la presentación más formal. Primero quería dar la bienvenida, por supuesto, tanto a Juan como a Bernardo Cremades, que nos acompañan aquí en la mesa, Marta Martini, que es la coordinadora del CIAMEN y ha sido fundamental en toda la organización de este acto. Le agradezco muchísimo todo el trabajo. Agradezco en particular al profesor Bruno Simma, que está aquí con nosotros, porque como sabréis tuvo un pequeño problema de salud, que es lo que hizo que tuviéramos que retrasar esta conferencia. Afortunadamente ya está perfectamente y ha podido venir también con su mujer, que nos acompaña aquí, que también saludo muy cordialmente. Bruno Simma, como contará Juan Fernández-Armesto, es muchas cosas en el mundo del arbitraje y en el mundo del derecho internacional público. Yo, por la parte del derecho internacional público, en particular, pues es una gran satisfacción porque es una de las grandes figuras como discípulo de Alfred Fredros. Estaba contando antes que hay un cierto vínculo con Alfred Fredros y esta universidad, que es Antonio Trujol. Antonio Trujol y Serra, maestro de internacionalistas, fue profesor emérito en la Universidad de San Pablo CEU, estuvo siempre muy vinculado en realidad al CEU, y Trujol era amigo de Fredros y tradujo un libro fundamental suyo de su derecho internacional público. Y Bruno Simma es pues, uno de los grandes discípulos de Alfred Fredros. I'm speaking in Spanish, so Professor Simma is following every single word, I think, perfectly. But I was just mentioning this anecdote concerning Antonio Trujol and Alfred Fredros. I think that they had a very good intellectual connection as well, and he did a great translation of his book at the time. And you being one of the main students of Alfred Fredros, I think it's a joy also to make this connection to Antonio Trujol. So anyhow, welcome to everybody. I hope that now something is being heard from what I am saying. I am going to give the floor. Okay, Andreas, a good friend from Germany, so he's telling me that you can listen to me, you can hear me. So I'm going to give the floor immediately to Juan Fernández-Armesto to make the presentation of Professor Bruno Simma, Judge Bruno Simma, and then Professor Simma will deliver his lecture. As you can see from the title he has chosen, it is really, coalface is a difficult word to understand, coalface, but once you get it, it's very clear. It's really, you will explain it, wonderful. So I don't need to explain that. So it's very much coming from his experience as both arbitrator and judge at the Hague. I suppose that is the basis of his lecture. So welcome very warmly to Professor Bruno Simma and to all of you. to this 13th lecture of the Hugo Grocio's conferences. And I will give now the floor to Juan Fernández-Armesto.
Dear Judge Simma, dear friends, dear colleagues, it's an honor and it's a pleasure to present Judge Bruno Simma, who will give, it is the 13th Conferencia Internacional Hugo Grocio. Now, dear Bruno, I hope you are not superstitious, and I hope that you not think that to be the 13th speaker is a bad omen. I am not superstitious, but I come from Galicia, and we have a saying, yo no creo en las meigas, pero a ver, haylas. I do not believe in witches, but exist. Of course they exist. And the CIAMEN has, and José María, they have organized 12 Hugo Grocio lectures. No glitch, everything was perfect. And then comes the 13th edition. And you fell ill. And the lecture had to be postponed. So let's look on the bright side of life. Always the bright side of life. The bad luck has now run its course. And dear Bruno, you have come very lightly out of it, as we all see. And instead of coming to Madrid in a rainy season, you have come when the sun is shining. It is an honor. It is an honor to introduce to you Judge Simma, because he is uno de los grandes, one of the towering figures of international law. He has been, yes, yes, you could be a bit taller physically, but we were speaking about international law. And he has been everything, and I will be short, it's so long the list, but he has been professor, he has been dean of the University of Munich, University of Michigan, he has been member of the UN Committee for Economic, Social and Cultural Rights. No idea, we have the ambassador here who can tell us what it means, but he has been a member of the International Law Commission. That I know what it means. It is a high honor to be one of the creators of international law. He has written, I am told, 15 books and 120 publications. He has a special person who keeps track of the number of publications he publishes. And he has, of course, the most famous, as all of you who devote your life to international law.
In Germany, you could say you have somebody who writes the books.
That in Spanish is called un negro, but that is not politically correct. And he has a commentary on the UN Charter, and it is 2,600 pages. So you can write 2,600 pages on the UN Charter. It is in English, it is in excellent English, by the way, because Professor Simma speaks very, very good English. He has not only been an academic, he has descended from the ivory tower of the university, and he has dirtied his hands also as counsel. His most famous case is the Lagrand case before the International Court of Justice, which pitched Germany against the US, and where Germany was insisting that German prisoners on the death corridor in the United States were still entitled to consular protection. Bruno was the agent for Germany, and I am glad to report to you that he and the German team won the case by goleada against the US. Goleada means household. So this is the translation into German. And then in 2003, Germany proposed Professor Simma as judge before the International Court of Justice in The Hague. And he was elected to the position. He was there for 9 years. He said, if I am correctly informed, on 17 cases, and he gave 6 dissenting opinions. So it's 1 dissenting opinion every 3 cases. And the boss of the court was Rosalind Higgins, and she was the president, let's say it, and she has written an interesting description of the work of Judge Simma in The Hague. And she has positive things to say about you, even if you may be surprised. Bruno, she says, she admires your scholarly achievements, your dynamism, your total lack of pomposity, and that we all appreciate. He says that you also use vigorous colloquialism, whatever that means. But although, of course, he has nice things to say about you, I notice a certain tension. She has a feeling that Judge Simma, and I quote, has not greatly enjoyed his journey from academic to judge. She says that Judge Simma has shown, quote, a visible threat of discontent with the approach of the court to its work. She goes further. She says, I notice, that's not me, that's Rosalind Higgins, a sense of impatience, indeed irritation with the court in his dissenting opinions. You wanted apparently to have things decided, and the court wanted to sly away. And she says that in one dissenting opinion, you proffered a highly critical language. And I will give you an example of what Professor Simma can say. He was referring to the states, and he was referring to the states and the human right field. And he said, the states are schizophrenic pack of wolves talking about protection of sheep. States, schizophrenic pack of wolves. So yes, it is forceful language. And after his career as judge, Professor Simma has had also a very distinguished career as an arbitrator in investment arbitration. And he has said in more than 20 cases, some of them very well known, like Bilcon and Ambiente Uficio. He has also 2 cases with Spain, KS Invest and Renergy, and one award was published very recently. And yes, you are a friend of Spain, but you decided against Spain, but we bear you no grudge, Judge Simma. Spain has a surprising, very high respect for international law and for international adjudication. And if I may say something positive about my country, it is one of our best traits is that we have very little nationalism, and we have a high respect for international law and international adjudication, even against Spain. It is an honor, it is a pleasure to present Judge Simma, because he is a friend of Spain. And there is this unexplainable reciprocal admiration between Spain and Germany. And I am, of course, being half German, I am an example of that. And it starts, dear Bruno, and I'm sure you know that, with our greatest king, Alfonso X el Sabio, the Wise, who is the founder of our legal system, and if I may say that, the intellectually most brilliant of all our monarchs. And I hope that His Majesty is not listening in and that he does not feel offended. Alfonso X el Sabio, the Weise. He is, why was he so wise and why he was such a brilliant? He was the son of a German mother. His mother was Beatrix von Schwaben. She was a Stauffer. And the only bad thing about, and it's an interesting lecture for international law, he wanted, his highest achievement was to become emperor of the Holy Roman Empire. And being a Stauffer, he bribed a lot of electors, and he actually was elected in Frankfurt. He was elected, but then the problem came. He could not enforce his rights. So this is this problem, which I think in international law you still have not quite solved, started in a Spanish-German situation in the 13th century.
I thought of Alfonso XIII.
No, that is quite later.
When you said the wisest, that was a little surprise.
Yes, I'm not surprised that the 13th, you did not think about him as very wise, but he was not half German. The wise one was half German, okay? And then we had, of course, a handsome Habsburg prince who bewitched an amorous Spanish princess, and we had 2 centuries of a common dynasty between Austria and Spain. And I think this Habsburg connection, that gives additional impetus with the bond between Spain and not every part of Germany, not the Prussian part, but your part, the Bavarian, Austrian Catholic tradition of Germany. And I have a feeling that this Habsburg bond has then translated in you, in your enthusiasm for all things Spanish, for our history, our Civil War, our mountains, and our historic cities. So you will now speak about the coalface of international law and how you take decisions at the Hague Peace Palace by arbitrators and judges. And there are two reasons why you and only you could have chosen this topic. Because you are a master of, as Higgins says, vigorous colloquialism. And so you are there to compare arbitrators and judges with coal miners. And because you are one of the few, if not the only person in the world who has the personal experience to explain firsthand the difference between decision-making at the International Court of Justice and in international arbitration.
Oh, thank you. Can you understand me well? Okay, fine. Well, I would like to first thank Professor Beneyto for his invitation to me to this place. It's my second time in Madrid, and I'm very glad to be here again. I remember last time was beginning of December, and it was maybe the weather was a little bit more comfortable, but this will be the high point. Then I would like to thank my friend Juan for his introduction, but I do it with mixed feelings because in a way, Juan, you didn't do me a favor. You made such a great presentation here that I simply cannot live up to that and speak for about an hour at the same level of maybe not these rough colloquialisms, but just the wit, etc., and the memory. And you're mentioning the wrong king, which of course, well, the wrong king in my memory, which of course made me remember the many conversations I've had about Spanish history in the first half of the 20th century, things like that. But you're right, I love Spain, and this is actually my first trip abroad. Second one, I don't count the first trip abroad for fun and for give a lecture after my encounter with COVID-19 in its light form. And I think I'm in pretty good shape because now at a temperature of 32 degrees, I had on the open air, I had a lunch of chaos, which is my favorite dish. I might be the only German also. And I'm still alive and apparently capable of giving these lectures. So okay, I'll just start. When I thought about what title to give to this lecture, I encountered the expression of somebody or something being at the coalface. I think it was either Gary Bourne. I think it might have been Gary Bourne. I don't know at what occasion. Something being at the coalface. And in connection with the person, that means that person, she finds herself doing the hardest part of a job, really there where the hard work is being done. A thing at the coalface, consider mining, it doesn't have to be coal, it can be the search for anything we need. And turning to our world, that world of the law, it will be the search for legal solutions. That being at the legal coalface means somebody at the search for legal solutions acceptable as hard, mature, durable, binding. The coalface, those being the place where legal ideas and theories are put to the test and the last word is spoken. And from there, we turn to let me turn to the Peace Palace. And I would submit that for an international lawyer, this is indeed the place where this description, the coalface of international law, corresponds closest to reality. The ICJ, International Court of Justice, and the Permanent Court of Arbitration under the same roof, the place where judicial and arbitral decision making is taking place side by side, and often even at the same time, and maybe the two institutions fighting for rooms more very, very frequently. Let me therefore take you on a tour of the Peace Palace and its two wings. PCA at the left, court at the right. The leitmotif of my will be a comparison between the main feature of these two institutions and the work they do. The strength and weaknesses, on the one hand, the ICJ as the world's most preeminent forum for the judicial settlement of disputes, potentially of all legal questions of international law. And on the other hand, the PCA as the oldest permanent institution of international peaceful settlement, arbitration, a creature of the Hague Peace Conferences of 1899 and 1907, originally designed for interstate cases, and at present taking care of more or less the totality of these cases, but in more recent years also expanding to other procedures like investment arbitration with an impressively growing caseload. The problem I'll have with my tour will of course be time. It forces me to be selective. The criteria for my selection might be a little surprising, but I hope not disappointing for you. I'll focus less on the essential features of judicial versus arbitral dispute settlement, with which you will be familiar anyway. Instead, I'll deal with certain practical aspects of the two techniques and venture to make some observations on points that are worth a closer look. I will concentrate on matters with which I am personally familiar. I've had the luck to be involved in almost all kinds of international dispute settlement at the court, and later on a number of interstate arbitrations, and present at the Iran-US Claims Tribunal, and in XIII, as well as in the PCA administered investor state cases, and finally many years ago in a few very funny sports arbitrations. And I could go on what the Americans call telling war stories for an hour about all the funny things there, but I'll be serious essentially. My lecture has 5 parts. I'll start with a few brief comparative remarks on matters of institutional authority, followed by some observations on the composition of the bench here and there, questions of the applicable law, working methods, and finally a quick look at costs. So let me first begin with some remarks on the authority of the ICJ as compared to that of international arbitral tribunals. And of course, here the ICJ occupies a singular position. It is, and I quote, the principal judicial organ of the United Nations, as it was said in the UN Charter, the World Court, as it's sometimes called, based in the Charter. If we include its predecessor, the Permanent Court of International Justice, it can now look back at 100 years of activity. In a way, everybody will be ready to grant it pride of place as the most vulnerable judicial institution in existence. But for a realistic assessment, this can only be the introduction to which some sober observations must follow. They are in place above all with regard to competence and jurisdiction. Let me start with the question of jurisdiction. In case of more modern courts, like the Court of Justice of the European Union or the European Court of Human Rights, the founding instruments also establish and circumscribe compulsory jurisdiction of the court. Concerned, that is, states parties to these treaties are automatically subject to the court's jurisdiction. In the case of the ICJ, at first the picture is genuinely impressive. All states that are members of the United Nations are, according to Chapter 14 of the Charter, ipso jure also parties to the court's founding instruments, the statute, which on its part is an integral part of the UN Charter. As such, the members of the United Nations are subject to what the Charter itself has to say about the UN's principal judicial organ. There is a chapter in the UN Charter, Articles 92 following, according to which, and I quote from 94, each member of the United Nations undertakes to comply with the decisions of the ICJ in any case to which it is a party. If a party to a contentious case fails to implement the judgment, the other party may have recourse to the Security Council, which is necessary if necessary, can decide about measures to be taken to give effect to the judgment. Unfortunately, and we have seen this very recently, again, the veto power of the permanent members of the United Nations also applies here, and thus this has remained an empty promise. Thus, if, for instance, Ukraine would bring non-performance of the obligations arising from the provisional measures that Ukraine obtained in a case recently brought against Russia before the Council, would bring against Russia before the Council, this would only have a symbolic effect, as the same is valid for the provisional measures granted also. Without being a party to a contentious case, the only clear legal obligation a member state of the UN will have is the duty to pay its share to the budget of the court. But the decisive point here is that the states parties members of the UN and of the statute are per se not obliged to make use of the court for the settlement of the disputes, however urgent and necessary this might be. All the relevant statute provisions do is to set up procedures on how to establish jurisdiction. They express an invitation, so to speak, to make use of the court by agreement, by consent. And this gets us to the other side of the medal, that of competence. Different from the situation before all other international courts, states can agree to bring disputes arising from any question of international law before the Hague Court. In this sense, and in this sense only, the ICJ possesses universal competence. More precisely, it is a potential universal competence, so to speak, because the court depends on willing customers, on their will both to subject themselves to the court's jurisdiction and, as concerns the questions of international law, they want the court to decide. It is the parties' consent that is governing both jurisdiction and competence, and here matters overlap with arbitration. Here is where the age of the court shows. It shows what was possible to achieve as to compulsory jurisdiction 100 years ago, and that has not changed since then. But before I go on, let me just say that it is precisely due to what I have called the potential universal scope of subject matters that come before the court that makes being a judge at the court interesting and challenging. Just positive. To regard the court statute as what could be called a mere starting point for the founding of its jurisdiction, and then counter this by pointing to the great variety of questions of law to be decided, may appear to you, at least to some of you, as a rather technical approach to the topic of the ICJ's authority. Let me therefore add that, of course, the judgments of the court enjoy great authority also in the usual sense of the term. Many of its decisions are in practice accepted as formulations of the law. Some of its judgments are household words among international lawyers. Frequently, the voice of the court turns candidates for norm status into lex lata, so to speak. Article 59 of the statute may decree that, I quote, the decision of the court has no binding force except between the parties and in respect of the particular case. But in regard to many principles and rules of international law, this limit is a merely theoretical formal point. For a permanent court like the ICJ, it is obviously much easier to build a jurisprudence constante. The court has done so in many chapters of international law, a particularly impressive example being maritime delimitation. The composition of the court, representing the principal legal systems of the world, supports this authority. Well, I'll get to some details a little later. The same is true of the court's working methods, which secure the contribution of every member to its work, as well as the relative transparency of ICJ proceedings. In summary, the court is highly regarded in the world of states. They are generally satisfied with its work. This is also proven if we compare it with an institution that in the 1990s was designed to pull the rug from under the court, at least within Europe. And I think if I was on with the French being the instigators, the OSCE, Court of Arbitration, of Conciliation and Arbitration, created by the Stockholm Convention of 1992, it has remained totally unemployed. There have, of course, been challenges to the authority of the court, and the ugly fact is that the gravest of these challenges stem from Western countries. Here I think, for instance, of the position of the United States after the ICJ had in 1984 accepted jurisdiction in the Nicaragua case. 20 years later in the Mexican death penalty, the Medellin cases following Lagrand. But the medal for the bluntest and most express refutation of an ICJ judgment now goes to Italy, more particularly the judgment of the Italian Constitutional Court of October 2014, number 238, and around 25 decisions by Italian domestic courts following that were rendered since the ICJ's judgment, that is 2012. The case the ICJ decided the judicial immunities of the state, Germany versus Italy. This is a sad story for more than one reason, which will now get a new chapter through the German application of a couple of 3 or 4 weeks ago, directed against this express repudiation of the 2012 judgment. And this is a real drama, which will deserve more than just these few remarks. I had in my original manuscript, I had 4 references to a discussion period. And then my legal advisor kind of said, that's a little far, you know, the outsourcing to the discussion period. So I struck them out. There would have been one here, but I'm not even sure if we're going to have a discussion period. It's whatever is fine with me. And now to the world of, turn to the world of international arbitration in its regular appearance. With regard to the observations I made on authority as an issue at the ICJ, what is there to say on interstate arbitration in comparison? Some elements of a comparison should already have become implied in what I said about the court. Some other points will appear in what I will say in other parts of my paper. But what needs to be noted instantly is that, of course, the greatest attraction of arbitration, which will reverberate on the authority of the awards, is the possibility to bring a dispute before a bench composed of hand-picked jurists possessing the necessary expertise in order to have the court decided by bespoke rules in a bespoke procedure. The parties have the choice between exposing themselves to transparency like before the ICJ, or curtailing transparencies still more or less as they wish. Just think of the question of publication, well known of arbitral awards. The parties to an arbitration remain masters of a case to a much greater degree than before the ICJ. The authority of awards in interstate cases will vary with the caliber of the arbitrators and the care they bring to hear. Another factor will be the degree of institutionalization of an arbitration and what could be called the approximation of the procedures used to those employed by an international court like the ICJ. Just think of a case handled by the PCA as the administrative authority, or if I may, the role of current or former members of the ICJ as arbitrators, to which again many things can be said. That would have been my second reference to the discussion. All right, let me say a few words on the composition of the bench, judges vis-a-vis arbitrators. In that regard, the picture is of course fundamentally different between the ICJ and arbitral tribunals. While it belongs to the very essence of arbitration that its participants can decide about the composition of that tribunal, it is equally axiomatic that in case of a genuine court, the motto is, I had Vogel, friss oder stirb. My assistant said, better translate, take it or leave it. I prefer the German. What is interesting here are the exceptions from that rule. Let us therefore have a closer look at those exceptions. First, some observations on the possibilities for a state to bring about a change in the composition of the ICJ. As you know, here parties have to live with the bench as it is composed at the time they file their application, and as it might develop, for instance, following one of the triennial elections to the court. The possibilities for a party to change the composition of the court for a specific case are very limited. Let me distinguish between, let's say, a negative versus positive ways to bring about the change. On the negative side, the question will concern non-participation of a particular member of the court in a specific case. Here we find in Article 17 in the statute, and according to this provision, and I quote, "No member may participate in the decision of any case in which he has, at the time he has previously taken part as agent, counsel, or advocate for one of the parties, or as a member of a national or international court, of a commission of inquiry, or in any other capacity." And then it goes on, any doubt on this point shall be settled by decision of the court, end of the quote. The matters in question here can, of course, also be brought to the attention of the court by a state party, at least by a state party, let's say party to a current case then. A further relevant provision of the statute is Article 24, which deals with cases in which either a member of the court considers sua sponte that for some special reason he or she should not take part in a particular case, or in which the president of the court is of that view. Also here, in case of disagreement, the entire court will have to decide the matter. And also here, the process can be triggered by a communication on the part of a state. Interestingly, instances of application of Articles 17 and 24 have remained extremely rare. During my 9 years at the bench, it only happened once, namely in the course of the proceedings leading to the court's wall opinion, that is the separation wall established on Palestinian occupied territory, which was decided in the sense of an opinion being decided in 24. When Israel, which had decided that it would not formally participate in the advisory proceedings, nevertheless brought the attention to the court to the role played by the then Egyptian Judge Nabil El Arabi in the Arab-Israeli conflict. He had been the legal advisor of the Foreign Office for a long time. The court decided, however, that the matters put before the court by Israel were, I quote, "not such as to preclude Judge El Arabi from participating in the case." And this decision of the court was the reason for Judge Bürgenthal, the American judge of Jewish ethnicity, to write a dissenting opinion, which more or less agreed with what the wall opinion says, with the exception that Judge Bürgenthal found that let's call it exclusion of Judge El Arabi problematic. That much about the legal possibilities for a state party to have a particular judge excluded from adjudicating. What I find striking here is the simplicity and narrowness of the statute articles on the matter and the extreme rarity of cases if you compare it with what we find in international commercial and investor state arbitration. Now, this is a part of your daily life, probably dealing with these things, reading, seeing whether a special colleague that you particularly dislike was, let's say, excluded, etc. Okay, and so I don't want to have to say more here. Cases like the one I described from the ICJ's wall opinion do occur also in interstate arbitrations, but as before the court, they are very rare and even more rare to succeed. A recent example would be the challenge of the arbitrator Chris Greenwood, now my colleague at the Iran-US Claims Tribunal, appointed by the United Kingdom in the case of brought before the PCA of the Chagos Marine Protected Area Arbitration, which also failed. But in the view of many, this story was one of the reasons why I think for the first time in the history of the ICJ, the election did not bring about a British judge. So Judge Greenwood had to move over to the Iran-US stuff, which of course is at another level. Now, enough of the negative. But what we find on the positive side of ways to bring about a charge in the composition of the court is the figure of the judge ad hoc. You will be familiar with the big brushes here. Article 32 of the statute is devoted to them. If, for instance, Spain would bring a case before the court, or another state would bring a case against Spain, and with no Spanish judge included on the bench at present, Spain could choose a person who would then take part in the proceedings and the decision of the case on terms of complete equality with their colleagues, also extending to the full immunity of an ambassador. Judges ad hoc are thus a sort of judicial hybrid. They evidently add to the arbitral element in the court. Now, the most observers and writers are very critical and regard the institution of judges ad hoc as obsolescent and useless. But there you really have to distinguish whom you talk about. It's not valid for the judges ad hoc. I must confess that I have a certain personal regard, interest in the matter. I've been appointed a judge ad hoc in a couple of cases and offered the job several other times. And of course, it's a great job. For instance, if a case carries on for 5, 6, 7 years before the court, you have your immunities. You can buy 2 new cars or 3 new cars, and so it's not bad. But I would still away in seriousness plead not to throw out the baby with the bathwater. In a case on maritime delimitation, judge ad hoc will secure the appointing party not much more than 1 additional vote. But in another case that has to do with complex issues of domestic law, an ad hoc judge, namely a national of the country in question, might well save the court from making embarrassing mistakes. This observation is based on my personal experience during my years at the court. Again, something struck out, reference to the discussion. For a former regular member of the court, returning as a judge ad hoc is also an emotional matter, and sometimes also a very effective medicine against homesickness for the court. For an international arbitrator, appointment as a judge ad hoc is a mixed blessing. The financial side is not attractive. For an 8-hour day you invest in court work, you receive what a regular judge earns per day of the year, which is around 700 euros. Well, at least this is not taxed in Germany, and probably, no, it cannot be taxed in any country because there's this Convention on the Privileges and Immunities of the United Nations, according to which every UN member has to, let's say, respect that. On the other hand, I happen to know a few top figures in the international arbitration world for whom serving as a judge ad hoc, particularly for their home country, signifies or signified the absolute peak of their career. Whether these personalities will take their role seriously is another matter. And also here, without mentioning names, my experience at the court provides me the examples along an entire sliding scale. From judges ad hoc, which were instrumental for a decent judgment, to judges ad hoc, which took the floor when they had heard something which impressed them, said, yeah, this is now my view. I had one morning where a judge ad hoc, very prominent Canadian judge ad hoc, changed his view 4 times and then had to recuse himself because some company, some mining company somewhere in the world had a problem, and so we understood and let him go. Let me conclude what I have to say on ICJ judges as to the, namely on expertise. As to the desired expertise before the court, too strong specialization might sometimes get in one's way, considering the multiplicity and diversity of the questions put to the court. And the majority of the court's members has traditionally been made up by generalists. This makes the search for and use of expert knowledge particularly important and particularly problematic at the ICJ. This has not been a glorious chapter in the court's history, even though it appears to gradually develop, the court appears to develop a gradually less hung-up attitude. ICJ judges are elected for a tenure of 12 years. Thus, contrary to the situation at other international courts, there exists no age limit. But you can read that somebody at the age of 81 can still be quite, you know, I mean. these judges can be re-elected several times, and 27 years as a member of the court represents the current record. And there is a possibility that one of the members who came to the court at the age of 44 will bring that record up to 36 years. And I wish him luck. He's one of the best judges of the court. And here I cannot spare you a joke. You know, the Dutch newspaper has a prize for something they know, etc. And the first prize is a week at the Hague, and the second prize is 2 weeks at the Hague. So this is a bit in Rosalind Higgins. But the serious question is re-election desirable? I would answer with a clear no. I would, and not because I've only done my 9 years. I would be in favor of a tenure of 12 years with no possibility of re-election. This would, among other things, also have the effect of sparing you the reading of many, in particular, separate opinions, which not infrequently appear as reminders that their authors are still around, and above all, very willing to stand for re-election, rather than making relevant points. Like I always said, like a graffito, Bruno was here. You know, this intention will become more apparent the more the opinion is self-referential. And maybe some of you who know the court and its members know whom I mean here. I conclude my observations on the stature of judges at the IK court with some observations on the possibility of the court doing its work in chambers. The statute speaks of chambers in a variety of appearances. There's a chamber of summary procedure mentioned in Article 29. There are chambers of the court formed with for special kinds of work. For years, we discussed whether a human rights chamber would be a good thing, but we finally desisted from doing so. And then there is a category of chambers which the ICJ introduced in the 1970s when there was no case around, and the court engaged in an exercise of kind of making itself more attractive. And the first case was the Gulf of Maine case, and this is the only, that's a variety of chambers that plays an effective role in the work of the court. The role has remained modest, at least in quantity. Parties appear to think that if they have decided in favor of going to The Hague, they should get the entire performance, mentioned, done, shown. There will be no difference as to costs, and I'll get back to the issue of costs a little later. And finally, it has been precisely one of the strengths of the ICJ that all of its judges, in principle, all of the cases have to some degree taken part in the court's decision-making. So you will get everything from the 15 plus eventually 2 more judges in a judgment. Let me now turn to international arbitration, and here to its interstate variety. As a rule, arbitral tribunals in interstate cases consist of 5 members, 2 of them appointed by the parties to the dispute, the other 3 in a number of different ways set out in the arbitral agreement. For instance, the agreement on the basis of the relatively recent arbitration on the land and maritime boundary between Croatia and Slovenia provided that the parties would jointly appoint the tribunal's president and 2 members within 15 days, drawn from a list of candidates established by the president of the European Commission and the member of the Commission responsible for the enlargement of the European Commission. If no agreement could be reached within this delay, the president and the 2 members would instead have been appointed by the president of the ICJ. Okay, I would have a very funny story about it. Within another 15 days, Slovenia and Croatia would have to follow with the unilateral appointment of their members. Otherwise, this would have been done by the president of the tribunal. In another case in which I participated, the Indus Waters or Kishen-Ganga arbitration between Pakistan and India, the Indus Water Treaty of 1960 provided that the tribunal would consist of no less than 7 arbitrators, but not just any 7. A problem with hearing? If the mic is out? Oh. There must have been somebody watching very works again. There must have been somebody not liking the little side remarks. All right. So the Indus Water Treaty provided that the tribunal will consist of not less than 7 members, but not just any 7. Each party could appoint 2 arbitrators. I was appointed by one of the 2 Pakistan arbitrators. The 3 remaining members were to be chosen by 3 different appointing authorities, each with a particular focus. The Lord Chief Justice of England and Wales appointed a person well versed in international law, so just at least to have one decent international lawyer on the bench there. The rector of the Imperial College of Science and Technology in London appointed a highly qualified engineer, while the Secretary General of the United Nations chose a person qualified by status and reputation to be chairman of the Court of Arbitration. And that's how Steve Schwebel became the president of the tribunal. The end result was apparently the largest arbitral tribunal in modern history, but I can report that despite its size, it worked as smoothly and efficiently as any other such body. What I found particularly helpful was that the technical expertise we needed in this highly complex case was provided not just by experts employed by the 2 parties, and preferably as counsel so that no cross-examination could take place, or as happens in the ICJ, by court-appointed experts, sometimes without the parties knowing that somebody is working in the court as expert, so that the former registrar of the court spoke of expert fantôme. Our expert was a full member of the tribunal who could ask questions to the parties and participate in all deliberations. Our engineer hydrologist did an admirable job. But of course, this cannot detract from the problem of the red lines in the roles to play by lawyers and experts in the rendering of legal decisions. That gets me to the law to be applied. First, the sources of law applied by the ICJ. We are all familiar with that stuff, Article 38 of the statute, and the pedigrees mentioned there, treaties, international customary law, and general principles, with international jurisprudence and academic doctrine serving as a kind of media, opening this triad up to the user. For the court, the parties to the case have nothing to add or exclude from the list. Love it or leave it. All they can do is to agree to empower the court to decide a case ex aequo et bono, but we also know that this has never occurred. In principle, therefore, the court finds itself in a straitjacket of strict law. In practice, the court does have a little more freedom, be it through the availability of rules of law that call for judicial application leading to equitable solutions, and there are a number of these in the UNCLOS, the Law of the Sea Convention, or solutions created by the court itself, as it did in the North Sea continental shelf cases, by drawing what it called equity within the law. And as far as the parties to contentious cases are concerned, they anything but hesitate to bring all sorts of material before the court, a base of which in Article 38 would not be easy to establish. Of course, the source of international customary law traditionally has had a hard time to defend itself against dilution or references a la carte. Despite such developments, the ICJ will always find itself on thin ice when it moves beyond the established positivist boundaries of what we could call the customary law lex lege lata. It must be said in honor of the court that as a rule, it keeps being quite concerned about the legal basis of its finding. The problem with its treatment of customary law rather lies in the way the court frequently uses to simply posit custom without bothering much, if at all, with confirming its elements. Despite these attempts to handle Article 38 a bit more flexible, it is right here with regard to the law to be applied that interstate arbitration displays one of its greatest advantages. Here, the parties to a dispute are in principle free to define the law to be applied. They may limit it, for instances, to treaties as the only base for the decision of a boundary dispute. What happens more frequently, however, is that the disputing parties allow an arbitral tribunal more freedom. To me, this freedom appears to be connected with another distinctive feature of arbitration. The possibility to select the arbitrators will make it easier for the parties to authorize an arbitral tribunal to base its decisions not just on strict law, but also on equity. Of course, states could also agree to the ICJ deciding ex aequo et bono, but the degree of unpredictability will undeniably be higher if the assessment of what constitutes a generally equitable solution is left to 15 or more judges of different backgrounds and legal traditions, maybe only sharing a strong conviction of their own infallibility, instead of a small number of hand-picked experts. That is probably why the provision allowing for equity before the court has never been made use of. And here again, the PCA supplies us with an interesting exception to the rule. Unfortunately, interesting also in the Chinese sense of the word. But before I turn to it, let me give you a couple of other and undeniably successful examples of choices of applicable public international law. The first example is the Eritrea-Yemen arbitration. It was based on an arbitration agreement concluded in 1996 and unrolled in two phases. The first one leading to an award in 1998 on sovereignty on land. And I remember when I read that as a sovereignty on land between Eritrea and Yemen. So it turned on, it dealt with islands. So land in the sense of islands that, to be rendered by drawing on, and the statute read, no, so the arbitration agreement read, I quote, "You draw on principles, rules, and practices of international law applicable to the matter, and on the basis in particular of historic titles." The second phase was devoted to maritime delimitation and led to an award a year later. Here the arbitration agreement directed the tribunal to decide on the basis of, I quote, "the opinion that it will have formed," that is, opinion formed in the first phase, "on questions of territorial sovereignty, the United Nations Convention on the Law of the Sea, and any other pertinent factor." My second example is the Iran-Rhine arbitration between Belgium and the Netherlands, the first interstate arbitration in which I took part as an arbitrator under the presidency of Rosalind Higgins, at the time the only woman at the ICJ. In this case, the tribunal was directed to decide, which it did in 2005, I quote, "on the basis of international law, including European law, while taking into account the parties' obligations under Article 292 of the EC Treaty," actually very topical in the area of Achmea and Comstroy. I will deal in more detail with my most recent example from the world of the PCA. It is the land and maritime arbitration between Croatia and Slovenia, with its final award rendered in 2017. The case had its origin in the fragmentation of Yugoslavia and the ensuing dissatisfaction of Slovenia with its newly established maritime boundaries with Croatia. The most important issue was that on the basis of the strict lex lata of the law of the sea, maritime traffic to and from Slovenia's main port Koper would have to pass innocently, but still, through Croatia's territorial sea. Slovenia thus elevated its claim to, quote, "to maintain territorial contact / in the original access to the high seas," to what it called a vital interest, and made it the political quid pro quo requested from Croatia for agreeing to what Croatia on its part regarded as its equally vital interest, namely accession to the European Union. After almost a decade of futile bilateral negotiations, and with more than a little help from Brussels, the two states in 2009 finally agreed to submit the dispute to an arbitral tribunal. I served as one of the 5 arbitrators. The tribunal was mandated not only with the law of the sea questions that I have described. As the politically easier part of its work, the treaty provided that the tribunal was also to deal with a number of stretches, at around 30 stretches of land boundary between the two republics, on the precise course of which, despite comprehensive determination by a couple of binational expert commissions, on the ground, they had found no solution, so we had to find it. And I still remember very strange sessions at the PCA where you had Google Earth and you looked at an old house and a couple of trees, and you had to drive. Where do we draw the line between the house? Let the house better be on one side of the boundary, stuff like that. Very kind of a matter of, I don't know, strange, but interesting. But this was the harmless part of the exercise. Then followed the politically charged part to be implemented in two steps, as it were, the maritime part. In a first step, the tribunal was to determine the maritime boundary between the two countries, that is, the delimitation of the two countries' territorial sea. This was to be done by applying the rules and principles of international law in existence, first on the establishment of the boundary in the Bay of Piran, a very beautiful place, a very touristy place, establishing the boundary in the Bay of Piran as a boundary of internal waters and the point starting for delimiting the respective shares of territorial sea. Nothing terribly exciting, and everybody thought, at least the tribunal, this was going to be the easy part, that and the difficult part will be what follows, also in my lecture. But it came as a surprise, at least to me, that after the award was published, its most contentious provisions turned out to be precisely what the tribunal said about the course of the boundary in the Bay of Piran. We are talking about less than 10 kilometers in length, and the consequences on local fishing. And this was then taken to the European Union. I think the Court of Justice of the European Union decided that it would not meddle with the tribunals, let's say, public international law question, more or less didn't decide anything. The legally challenging part of the tribunal's task was through the following step: the establishment of what the arbitration agreement called Slovenia's junction to the high seas, In this regard, the agreement provided as follows: the arbitral tribunal shall apply international law, equity, and the principle of good neighborly relations in order to achieve a fair and just result by taking into account all relevant circumstances for the determination of the junction and the regime for the use of the relevant maritime area. This task was thus to be fulfilled not only by the application of the strict maritime lex lata, but also by reference to equity, that is, equity going beyond what the ICJ in North Sea continental shelf called equity within the law, or what we find in formulas on certain maritime delimitations in the UN Convention. This authorization gave rise to an extremely demanding task for the arbitral tribunal. Obviously, authorizing arbitrators to go beyond the application of relatively solid principles and rules of maritime delimitation by empowering them to resort to considerations of equity must increase the professional but also the moral burden on the shoulders of the arbitrators. But it will also raise the level of the parties' concern over the outcome of a case, particularly if they consider it as affecting their vital interests. This might have been one of the reasons for what then occurred. In our case, in July of 2015, Bernardo, it was on Mallorca, in Porte Sawyer. I was lying on a tree reading a book when the email thing, or the app or what you call it, came that something had happened there. What had happened? A Serbian newspaper published a transcript of what purported to be telephone conversations between the agent of Slovenia in the case and Slovenia's party-appointed arbitrator, revealing information about the deliberations of the tribunal and the feeding of certain materials stemming from the Slovenian Foreign Ministry into the tribunal's deliberation. In the days and weeks that followed, the Slovenian agent and the arbitrator appointed by Slovenia resigned. Croatia wrote to the tribunal that it considered the entire arbitration process to be tainted. Slovenia then appointed another arbitrator who again resigned, which actually a member of the ICJ, which was not a very terribly elegant move, because in such a constellation, things might have ended up before the ICJ actually. Slovenia declared that it left the selection of this arbitrator to the president of the tribunal, which was Monsieur Guillaume, the French Roman judge. Subsequently, the arbitrator appointed by Korea, I recently heard what Korea must have had to do with Ukraine, apparently. So from Croatia also resigned, and Croatia informed the tribunal that it could not continue the process in good faith and that it intended to retreat from the arbitration agreement and the process altogether due to material breach committed by Slovenia. Slovenia insisted that the case was to go on. In the following, the president of the tribunal replaced the two-party appointed arbitrators by other persons. The tribunal demanded of the parties to lay open the source of the information about the events I just mentioned. In the following, we had a hearing on permissibility and effect of the measures taken by Croatia. We decided that Slovenia's steps were not of a nature to have to stop the further proceedings and continued the work in a changed composition and delivered the award as planned. But certainly this story will reverberate for quite a while in the world of not just public, but also commercial international arbitration. As you might imagine, in the Croatia-Slovenia arbitration, the construction of the regime of Slovenia's junction to the high seas was a demanding but truly fascinating task, probably one of the most interesting pieces of work I've ever done. I'm still convinced that the junction area, which has not become practical because the conflict is still kind of making the Piran Bay unruly, and the legal regime we created, I'm still convinced, is the best possible solution. And if the two countries ever agreed, for instance, on a consensual solution without employing a third party, I'm sure, I would bet that the solution would be very close to what we. With these examples, I hope I've illustrated the freedom arbitral tribunals can enjoy, the creativity they are able to develop in interstate cases, if only their masters allow, as well as the challenges such creativity might encounter. There would be more examples. Just think of the Rainbow Warrior case, but I preferred, at least in principle, to give examples in which I was personally involved. I'm getting close to the end, so don't worry. Working methods. It is, at the ICJ, the working methods in contentious proceedings are long established and strict. They are determined in a number of instruments that find themselves in some kind of hierarchy: the statute, the rules of procedure, so-called practice directions, and then other texts dealing with the internal judicial practice of the court, the preparation of pleadings, or more recently, the organization of hearings by video link. Both as a judge and as a party, one finds itself in a dense web, and there is little that is dispositive. The proceedings, both involving the parties to a case and the internal working methods of the court, unroll in inflexible ways, reminding me of Hans Kelsen's formula for his Grundnorm: behave as you has always behaved. I won't deny, of course, that such regularity and foreseeability has many advantages. Indeed, it might be necessary to cope with clients as difficult as sovereign states. But I also remember from my own experience a number of occasions when all of this made me feel like in a straitjacket. At one occasion, I became so irritated by the direction into which I thought the case was moving, by will of the majority, that I wrote a spontaneous letter, just a one-page letter to members, and I was really duly reprimanded, and my colleagues were asked not even to read this one page. At other occasions, I felt that there were so many questions still necessary to be solved in difficult matters that the court, instead of proceeding to the next step, should have given members additional time to rethink a point and to really think a matter through to the end. But no way, the court's working schedule has to be followed. The next case is already waiting in line. Apropos waiting in line, another peculiarity of the court's methods, which derives from the simultaneous handling of several cases, or let's say having a number of, better expressed, having a number of cases on its list. This is essentially a good thing. Handle them more or less side by side or back to back. But in special, it can happen that in special circumstances, a case that was brought later in time will be allowed to go to the head of the line, understandable or even necessary in some cases, But the effect will be that in your case, if the parties let their cases fall back that way, which of course might possibly also be in the interest of the Foreign Office involved, might hang around for a long time. Like in the Zilala case between Peru and Chile, which has been deliberated, I think, a couple of weeks ago. And after having been brought in 2016, that is 6 years ago. In the world of arbitration, things are very different. And let me state right away that this is one of the main reasons why, as an international arbitrator, I felt freer than during my 9 years at the ICJ. There are, of course, rules of procedure to choose from, like PCA rules 2012 or the XIII and Untitled rules in the field of investment arbitration. But you do have a choice of a regime in the first place, and then you can agree to turn rules into provisions custom-made for the cases at hand. In fact, very little of procedural arbitration law is so inherent to the nature of arbitration, interstate particularly, to lose its dispositive character, as long as you maintain a level playing field by treating the parties equally. Time will be much less of a problem. Matters out of control may always arise, but as a rule, the parties are in a position to determine the complexity, and with it, the time an arbitral proceeding may take, like limiting the number of written submissions, or even going as far as determining the length of proceedings, like it was done in the so-called Hague arbitration before the PCA in 2009, which took less than a year. Unfortunately, the truth of the saying, good thing braucht Weile, good things take time, subsequently showed in the fate of this award. Last point, very briefly, costs. In my last chapter, a few observations on the nervus rerum, the costs of litigation. As to the ICJ, you will know that you can use the ICJ free of charge, but of course you will have to bear the fees and expenses of your legal team. In the choice of counsel, professors are as a rule much cheaper to get than partners of big law firms, supported by flocks of associates. I remember a case where we deliberated in Berlin about the preparation of a case, and we had hired one American lawyer who had played a role in a preceding case. It had to do with consular assistance, and then the meeting ended a little early, and so the guy said, as you are used to do in arbitration, you know what, I can get an earlier flight to New York, can you book? I mean, aside from the fact that the Foreign Office was not really able to book the flight in time for him to catch that plane, they had weeks afterwards to deal and fight about the bill, because in the German, let's say, bureaucracy, you cannot just take the plane and then you have, that's all has to be provided beforehand. That is okay. That is why you find academics in large numbers before the court, relatively speaking. I particularly admired Spanish professors. They looked like people that were going to be burned on a stake in the 16th century in your country, this with a hat on and so on. I appeared before the court as counsel first for Cameroon in the Bakassi case, and then for Germany in Legrand. What I learned from these cases was that if you work for your own country, you better have a substantial sense of patriotism in which to find compensation. I think I was told that the French, when they work for France, don't get any fee. In the ICJ, no cost shifting of any kind takes place. But in order to make the ways for the court easier for developing countries, there exists a trust fund available in cases brought before the court, but only in cases brought by way of special agreement. How do costs of international arbitration compare? Here, all I want to say relates to interstate proceedings, because to lecture an audience like tonight's on cost issues of international commercial and investment arbitrations would be like carrying coal to Newcastle, to use my initial metaphor. In interstate cases, the cost of a party's representation will not differ much from those incurred before the ICJ, with the exception that if you go to the court, don't forget to hire at least one native speaker of French in order to appease the relevant judges. It's very important. And of course, you will have to bear the expenses of your counsel irrespective of whether you win or lose. I'm not aware of any interstate arbitration in which a tribunal would have decreed cost shifting. Let me finish my remarks that this is some kind of a high point, a special treat. I disclose a trick by which one of the advantages of arbitration, namely the custom-made composition of the bench, can be made use of while escaping the, let's say, disadvantage of arbitration, namely the bearing of the fees and arbitrators for the fees and expenses of the arbitrators. The recipe is a mix of judicial and arbitral elements. Go to the, if you have two countries, go to the ICJ and there choose an ad hoc chamber procedure in a composition of 5 members, which is the rule anyway. Next, the two of you, the countries, suggest to the court to elect 3 of the court's members, judges that you want to see on the bench, none of them of your nationality. And you can almost be 100% sure the court will follow your suggestion because it is keen on getting business. This is actually what happened the very first Chambers case, Gulf of Maine, where Canada and US say we would like to have Judge, I think Mosler and I don't know, 3 people. And if these people are then elected in a secret ballot by the ICJ, but the secret ballot had the result that the parties wanted. So the result, and then you can appoint your own judge ad hoc to the case. That makes it 5. The result will be a chamber of 5 members. In the appointment of all of them, you'll have had a say. And the outcome will be a chamber resembling an arbitral tribunal made up entirely of ICJ judges, paid by the UN, but rendering a genuine court judgment. All of this free of charge. Okay, this brings me to an end. My lecture, I've never been good in end parts of lectures. I could only offer a selection of points of comparison, and I'm afraid that some of you might have waited for me to cover questions of great current importance or rougher language. I'm very sorry about that. Main reason is I didn't have the time, and then comes a topic like, for instance, what could the ICJ possibly play a role in regard to climate change? So everybody has to contribute. You better contribute by when you choose your next car, and the ICJ also better contribute. And but this would really, and I would be prepared to give you an additional lecture, but not tonight. So thanks for your attention.